Well, welcome, if I can kick off proceedings. Welcome on behalf of the Slynn Foundation and the British Law Centre to this evening's event. This evening's event is certainly very timely. Yesterday morning, I and the other members of the Supreme Court went to a meeting with the members of the House of Lords Select Committee on the Constitution. And we were discussing, amongst other topics, their recent report published at the end of last year. That's not the whole report, that's just the front page, called The Rule of Law, Holding the Line Against Tyranny and Anarchy. And the foreword to that report serves very well as an introduction to this evening's event. It says, taking little quotes from it, "For centuries, it has been recognised that a rules-based society is necessary to keep at bay the evils of tyranny and anarchy and to preserve our freedoms. The rule of law is about protecting the citizen from an overmighty state. It describes a framework of law and of checks and balances that exist to prevent the arbitrary exercise of government power. However, the rule of law is much more than this. It governs the relationship between citizens, facilitating a peaceful, stable and successful society that brings many benefits. So the rule of law protects us from the anarchy of mob rule as much as it protects us from tyrannical government." But the foreword finishes with a warning: the rule of law's endurance and vitality is not guaranteed. And it then goes on to highlight the threats that are posed by delays in court process, attacks on judges, including those from politicians. Ministers, it says, must make crystal clear that questioning the integrity of judges and spreading misinformation about their judgments is totally unacceptable. And it closes by saying everybody, but particularly those in public life, need to be proactive in strengthening our rule of law culture, and this must start now. Failing to do so risks the rise of extremist political parties, growing antipathy towards democracy, and ultimately creating space for a dictatorship of arbitrary rule. And the topics that are covered are judicial independence, an effective justice system, and the effect of law-breaking on a rule of law culture. And this is very much in the air. Last week I was at a panel discussion for the launch of a book by a former colleague, Ross Cranston, called simply Judging, former judge and former Solicitor General, and that also deals with the key values of rule of law, integrity, independence, and the impartiality of the judiciary. So the work of the Slynn Foundation, of which I have the honour to be a patron, and the work of the British Law Centre is very key and very much in the air and in people's thoughts. Now, the Slynn Foundation was set up in 1998 to provide training and support for judges and lawyers in countries that recognise a need for that training and support. They've recently delivered training in northern Cyprus, last year in Saudi Arabia, and in places as far-flung as Brunei. The founder of the Slynn Foundation was actually George Dobry, who was also the founder of the British Law Centre and had joint UK and Polish citizenship. And if I can just invite Professor Richard Fentiman, who's a trustee and the academic director of the British Law Centre, to say a few words about their work, and then we will get going.
Thank you. And I should say these are going to be a very few words because we have important business to get down to. I simply wanted to say that on behalf of the British Law Centre, I'm delighted that we can be involved in this. I'm delighted that our two speakers are actually two of our graduates, which gives me great pleasure. I should say, for those of you who don't know, for some 34 years, the British Law Centre has operated in Warsaw, and we have actually branched out into many other centres in Central and Eastern Europe. And our task all along has been to provide courses to university students and indeed others, to practitioners, on aspects of English law, but also English legal method. And this was very much the brainchild of George Dobry, whose name we've heard mentioned already. So I simply wanted to say that it's a great pleasure to be involved in this, and I wanted also to add my own words of welcome. Thank you.
Thank you, Richard. So, as I was saying, the idea that we must all be proactive in supporting the rule of law and not taking it for granted brings me to our speakers. We're very fortunate to have this evening two speakers who really embody that proactive approach to fighting for the rule of law and an effective justice system. Professor Adam Bodnar is a professor of law at SWPS University in Warsaw and a senator in Poland. He served as Justice Minister in Poland between December 2023 and July 2025, and in 2019 he was awarded the Rule of Law Award conferred by the World Justice Project for his, quote, outstanding efforts in strengthening the rule of law in difficult circumstances. Mikolaj Pietrzak is a Polish advocate and a former chairman of the Human Rights Council of the Polish Bar Council, and he specializes in criminal law and constitutional law and in the protection cases involving the protection of human rights. And he regularly appears before the Supreme Court of Poland and is on the list of counsel able to appear before the International Criminal Court in The Hague. As you know, the topic for our event this evening is the crisis in the justice system in Poland, and if I could invite Professor Bodnar to speak to us on that. Thank you.
Ladies and gentlemen, it is my great pleasure to be here with you. I would like to thank Steve Teret for organizing this event and for making it happen, that we could be together with Mikolaj being introduced so nicely. I think that the title of our meeting is The Crisis in the Justice System, and I think my role should be to say a few words about what happened in 2023, which was the year of elections, and basically why this moment was a breakthrough year regarding the rule of law crisis in Poland, and basically what happened afterwards, and why is it so difficult to repair the rule of law situation. I think the story between 2015 and 2023, the story of building the illiberal democracy in Poland is pretty well known. There are a number of books, there were a number of conferences, seminars, workshops organized even here in London devoted to this issue. But I think that we should remember that in October 2023, when we had elections, we faced the very intensive institutional damage to different judicial institutions. Moreover, it was the year when elections were about stopping different further risks that appeared in the Polish political life. The risk that was a result of the significant pressure on NGOs and human rights defenders by silencing them, by creating different methods of harassment. There was a risk of Poland exiting the European Union. There was also risk, and I remember this feeling that maybe these are the last elections which are still organized in a more or less fair way, and that if those elections are failed by the pro-democratic side, then basically we will not have a chance for any new independent elections in upcoming years, and basically that will repeat the story of Hungary. But also what was like the prevailing feeling at that time was the lack of any accountability of leaders for misuse of power, for using public funds for political purposes, for using secret services to target opposition or human rights and civil society defenders. And basically this moment was a great moment of hope and great moment of change. I even remember, I see here that there are representatives of the UK chapter of the Committee for Protecting Democracy, and I remember that even here in London I had a meeting in the context of upcoming elections. But basically we have this 15th October 2023, great victory of pro-democratic forces led by Donald Tusk. And 2 months later, the new government is formed. And basically, the major idea is how to repair the system. How to repair the system of judicial nominations, how to repair different institutions that have been abused and that were put into this into the format which is not fulfilling constitutional requirements, such as National Council of Judiciary, Constitutional Court, the Supreme Court, and how to basically do it, not having all possible instruments that should be at the disposal of those that have won elections. Because I would say, and I think it is important to remember, that it was an electoral victory in parliamentary elections, but because of the virtue of the Polish constitution, still the power is shared with President of Poland, who was still supporting the previous regime, as well as you cannot achieve certain significant changes without changing the legislation. Moreover, I remember that when I was appointed as the Minister of Justice, Prosecutor General, one of the challenges was how to deal with number of, I would name it, personal choices that have been made by lawyers that decided to participate in this illiberal system. That you cannot just say on the one day that you cannot work in this system any longer. You must find a legal way to deal with this situation. Moreover, we faced a situation when there was a lack of clear guidance because we didn't have a constitutional court that would operate in independent way. And final dilemma was how to make a rule of law recovery and to what extent you should operate within the rules that are existing, that are left by predecessors, and to what extent you should interpret those rules in a pro-constitutional way, or maybe you should basically ignore some of those rules in order to achieve a change. And basically, I pose those questions because that is something that we are still facing until today. I think that when we are looking back into last 2 years, we see that there were a number of changes already achieved in the justice system. First of all, I think it's quite important that the pressure by using disciplinary measures against Polish judges has been stopped, and we do not have any situations that judges would be suspended for the content of their verdicts or for using the EU law. In fact, Mikolaj Pietrzak was one of those lawyers who was representing pro bono some of the most prominent Polish judges in their fight for the rule of law standards. For sure, it was possible to change the management in courts, presidents of courts, and basically to put people who have trust of their colleagues, who are not just political nominees, but simply people who were elevated to those positions by their fellow colleagues. It was also possible to join the European Public Prosecution Office. And even today, when I was coming here, I learned that in one very serious case concerning Clean Air EU-funded project, there was a detention of one guy as a result of the action of the European prosecution. There were also changes in the operation of the prosecution service that opened the window for accountability process concerning people that were abusing power in previous years. But I would like to say that long-term changes under the Polish law require changes in the legislation. And unfortunately, it was not possible to achieve any significant progress regarding changes in the legislation affecting judiciary due to the position of the Polish president. Previous president, Mr. Andrzej Duda, who was basically saying that everything what he did, what he has signed, was, in his opinion, in compliance with the constitution and did not require any change. And also with the new president, Karol Nawrocki, who is also, I would say, following the same pattern of thinking. So I think it is quite a dramatic choice because on the one hand, there is a need to make a change in different aspects of the operation of the Polish judiciary, such as the operation of the National Council of Judiciary, which is like the major body appointing judges, or the Constitutional Court, which is responsible for the judicial review. And moreover, there is an effort by the ruling coalition, by the parliament, to adopt a relevant legislation, but then this legislation does not enter into force because of the veto or because of some other political possibilities implemented by President of Poland. So we are a little bit like in a situation of stalemate, where there is a conflict around certain institutions, where there are existing important judgments of the Court of Justice of the EU, European Court of Human Rights. There are opinions of the Venice Commission how to do certain changes, but because of the lack of political willingness and the growing polarization, it is not possible yet to repair it. And of course, the government and the current Minister of Justice have so-called Plan B, scenarios B for implementation of different other for making like a real change in the judiciary, but still the question is to what extent the implementation of this so-called Plan B is facing another crisis, another polarization in the Polish justice system. There is also ongoing effort concerning accountability for past abuses. When we look into, let's say, numbers, I think there are more than 15 politicians of the previous ruling party that have been already subject of their parliamentary immunity being lifted, and they face their cases, either they have been presented charges or they face indictment before courts. There are also investigative committees that have already finished their work, and one of them, the most important one concerning the use of the Pegasus spyware, is going to present its report, I think, in upcoming weeks. But this process of accountability is also facing a certain, I would say, political dilemma. So one of the major discussions in Poland is to what extent it is really about accountability and to what extent it might be used for some political purposes, and sometimes the discussion around the accountability process is not giving like a full trust towards the work of the prosecutors trying to investigate and name and shame different abuses of the previous era. I think right now when we meet, one of the major challenges is the situation of Polish judges. Please note that this whole system has been created in such a way that after 2018, to put it short, the process of judicial appointments has been politicized because of the change in the structure, in the operation of the National Council of Judiciary. After 2018, more than 3,000 judges have been appointed to the Polish judiciary, and there are more or less like three categories of those judges. One category are, I name them, rookie judges, so those who are just starting their judicial career after finishing the National School for Judiciary. There is like a second category, judges who just got a nomination to higher position thanks to the appointment made by the National Council of Judiciary. So they were, for example, district court judges, and they were appointed to the regional or appeal courts. And there are also judges who got like the first promotion, but from other legal professions, from being previously attorneys, prosecutors, or being scholars, and quite many of them were appointed directly to the Supreme Court. But the problem is what to do with them, and how to check, how to evaluate their status in a situation when, by virtue of the jurisprudence of both European courts, this status of judges adjudicating in individual cases could be questioned. And right now we are in a very, very specific and interesting situation, because on the one hand, the government has proposed quite a comprehensive law regulating this issue. This law has been more or less approved by the Venice Commission with some recommendations how to make it, I would say, better. But interestingly, yesterday there was a judgment of the Court of Justice of the European Union which said more or less that just mere appointment upon recommendation of the National Council of Judiciary to common courts is not enough to question the status of a judge. you must indicate some other, let's say, political circumstances of this appointment. But interestingly, this conclusion does not apply to the Supreme Court judges. Here, the Court of Justice is quite straightforward that those judges appointed to the Supreme Court, the procedure of appointment was basically with defective, and that is why their appointment could be questioned. But I presented this because irrespectively, interestingly, what happens with, let's say, governmental proposals, with the Court of Justice decisions, with the Venice Commission recommendation, at the end of the day, it seems there is still no willingness on the part of President to get into any discussion concerning reparation of the law. So it seems that this kind of a situation of polarization might be beneficial from a political point of view to the presidential camp. Ladies and gentlemen, I don't want to take too much of your time, but I would like just to make some conclusions, and I hope that in the discussion it will be possible to explain some issues in more detail. I think looking back into, let's say, story of Poland, we can be sure that what was important in the context of elections of 2023 and in the context of fighting for the rule of law was the resilience of the civil society and also very active position of the Polish judiciary, also creating those transnational networks, solidarity networks supporting each other. It was really an important lesson, I think, from Poland to all other countries. Second, I claim that without support, without the active intervention by the European Commission and the Court of Justice, without also decision to suspend EU funds, it would not be possible to stop the process of changing the situation in the judiciary. The third is that the rule of law crisis during first years was a little bit kind of abstract to the society, but over the time we started to feel that it has consequences for different other groups and especially vulnerable minorities. It had significant impact on protection of civil society organizations, on LGBT rights, on women's rights, especially the famous judgment concerning the restricted access to abortion of October 2020. But I think there is like one important, like a very general conclusion, is that if you put the rule of law situation under threat, and if institutions are subject of erosion, and this erosion happens like 1 month after the other, it is extremely difficult to rebuild the reputation, the legitimacy, not mentioning the legal status of those institutions. It is really a painful lesson to observe. Institutions that once were regarded as prestigious ones, as highly regarded, such as the Constitutional Court, which are right now in, I would say, total catastrophe. And I think that also it is Polish lesson still that we shouldn't take certain institutions and certain principles as granted. We shouldn't feel that because populism and those authoritarian trends are going towards undermining basically everything, and they are not respecting, I would say, those signed institutions of the rule of law, and they could be sacrificed at the altar of the daily politics. And once again, so that is why it is important for the legal community, for scholars to respond and to react to any threats to the rule of law. And I think that my final conclusion would be like looking at the result of presidential elections, but also looking at the possible discussions surrounding upcoming next year parliamentary elections, is that this rule of law recovery is not a process that has been finished, and most probably this discussion will be followed during upcoming parliamentary elections, and a lot of things depend on the result of those parliamentary elections, which shows how much vulnerable this situation right now is. Thank you very much for your attention.
I'm supposed to follow that.
Well, you're from the other side of the bench, as it were. So, yeah, thank you. It's very interesting.
Thank you, Lady Rose. It is, in fact, difficult to follow Adam. Not everyone here may appreciate Adam's role over the past years. I find it difficult to do this because the norm is to tease Adam. He's a dear friend. We've worked together in NGOs and fought windmills over the years together. But Adam is a hero, and I think that has to be said out loud at every possible occasion. Adam was the face, literally the face, of the defense of the rule of law between 2016 and 2022. He was appointed as the human rights ombudsman moments before the populists took power. All other elements of the constitutional system of power were seized by populists. It was only the human rights ombudsman who kept reminding us what is right and what is wrong. And that voice in the darkness was Adam's voice. And that is the reason why, to this day, when I go visit my elderly mother, before she asks about her grandchildren, she asks if I've seen Adam and is he all right? Let that sink in, Adam. Well, now, barring that, with that awkward introduction behind us, my comments today, if you will permit me, are not going to be about the law. As once was the case, Polish lawyers would come to conferences and speak about the law, speak about the extradition mechanisms, in my case, criminal law, the Swedish roadmap for procedural rights. We never get invited to speak about these things anymore because of our experiences in the very sad case study that is the rise of populism in Poland. So my comments will be not about the law, but about lawyers, about the legal community and their stances, their choices, more about their morality, ethics, and sense of civic responsibility than about the law strictly. I'm speaking to you as a Polish advocate, as a lawyer, the former dean of the Warsaw Bar, which gave me a particular insight on what was happening in our community during the times of the populist regime. But I'm going to be speaking about values and stances that are common across the world for lawyers. I think we all, as lawyers, jurists, share a certain set of core values, and it was those core values that were undermined beginning in 2016 in Poland. In 2016, as Adam mentioned, the Constitutional Tribunal was attacked illegally, unconstitutionally, by the new populist majority in Parliament, so as to paralyze initially the constitutional review mechanism and then to seize control of it illegally, unconstitutionally, thereby making it possible to pass any law, regardless of whether it was constitutional or not. In 2016, the legal community rallied around the Constitutional Tribunal. We marched, we advocated, we filed amicus briefs, we protested, and we were convinced, as we looked around in the street, there's at least 50,000 of us under the Constitutional Tribunal. We've never seen this before. We've won. There's no way they're going to go through with these changes. We naively believed we had succeeded for a moment. We believed the institutions of democracy would defend themselves. We believed the systems of checks and balances, which we deemed obvious in our Constitution, would hold. That's what they're there for. That was naive. And that naivete is something I have since that time observed across the world with many of my colleagues, the greatest lawyers across the world in other jurisdictions, who also believe it can't happen. I'm here to tell you it can happen. And if we're talking about it now, it's already probably late to start acting. Adam told the story of the constitutional breakdown, how the National Council for the Judiciary was seized, the courts were stacked with illegally or illegitimately appointed judges. What I would like to tell you is what the Polish legal community did in reaction, and in hope that perhaps some of these good practices can be used in other states. Hopefully not in the UK, hopefully it won't be necessary. But certainly there are lessons to be learned and used right now in the United States of America, if nowhere else. So we saw over the years that advocates had three roles to play. Lawyers in large had three roles to play: advocacy, education, and litigation. Advocacy meant stepping outside our comfort zone, leaving our ivory tower, if you will, and getting in touch with politicians, opposition politicians, getting in touch with political actors on the European scene, getting in touch with diplomats, getting in touch with people who could influence the populist government in Poland and try to slow down the destruction of the constitutional system of safeguards. This meant being very vocal on issues in which bar associations and lawyers thus far, and certainly judges, would not be vocal. We faced criticism that we were addressing political issues. And in 2016, the legal community, certainly the bar associations, faced a very real dilemma. Are we ethically permitted, as a bar association and as a legal community, to voice our concerns over bills, about laws passed by government? Is this not partisan? And we quickly came to the conclusion that it is not only, in fact, all right, but it is our deontological duty to be very vocal when very basic principles underlying the security of the rights and freedoms of our clients, of citizens of Poland, are under threat. That, in fact, by not being vocal, we would be like the community of physicians who remained silent when the system of public healthcare was being taken apart, or vaccino-skeptical, is that a word? Vaccine skeptics seized power and influenced the public healthcare system so as to diminish the physical security of patients. We came to the conclusion that there is a difference between being vocal on political issues which affected the very core of our profession and the very foundations of the procedural aspects of rights and freedoms in Poland, and being partisan. We not only could but should be vocal on political issues where they concern the values which we swore to uphold. But we should not be partisan in choosing sides and supporting issues depending on which party was supporting them. That is a very difficult balancing act to defend publicly. We strove to convince all parties involved that that was our point of view, but were consequently deemed as traitors or political actors by the Law and Justice government. Interestingly enough, the legal community in Warsaw, and in fact in Poland, the lawyers, wasn't perhaps unanimous, but judging by the outcomes of bar elections, which came to symbolize these choices, 80 to 90% of members of the bar were against the reforms introduced by the Law and Justice government. Conservatives, liberals, those who believe in God and those who do not, all supported choices in the bar which were very strongly against these, well, the reform isn't the right word, against the destruction of the rule of law in Poland. Advocacy played a large part in what we did. I was in touch with NGOs regularly, with the Human Rights Ombudsman, any actors who would hear us out and who wanted to take into account our expertise. We tried to get into Parliament very unsuccessfully. Part of the changes that took place under the populist regime was to cut off access for civil society to Parliament. But we got into other parliaments. We were invited by the French Parliament to speak. We spoke in Congress in the United States, met with congressmen and senators, and their support was incredibly powerful. Their support was like a snowball which gathered weight, strength, and size as it rolled on. And that footwork, I believe, played an important role ultimately in limiting what the populist government felt it could get away with. The other field in which the legal community became active, much more active than thus far, was education. And this is something we should have started 30 years ago. I still believe that if advocates, beginning in 1995, had been present in the school system, talking to young citizens on a frequent basis about the importance of the rule of law, what the separation of powers means for each individual, why their rights and freedoms are important, why the Constitution gives them power and security, and why it should be defended and the institutions of the Constitution should be defended, perhaps the populists would not have been so successful. Perhaps that knowledge would have been a vaccine against populism. But better late than never. In 2016, the bar associations across Poland, along with NGOs like the HODA Association and the Helsinki Foundation for Human Rights, our alma mater in many ways, got very involved in education. We started regularly visiting schools until the Law and Justice government cut that off with a new law barring NGOs from coming to schools. We started appearing at music festivals. We started setting up workshops in city squares for senior citizens. We started going to universities to meet with students who were not students of law, who didn't necessarily have an understanding of the Constitution, the importance of the system of checks and balances in the Constitution. I feel that was too late, but it gave us a good model to move forward. Unfortunately, I see that since the election in 2023 and 2024, I see that the motivation of many lawyers to continue this work has decreased. That is, I believe, a mistake. Just as it is a mistake to believe that we have won, we have succeeded against the populists. We right now are in the middle of a short respite, but unable to pass reforms, as nobody knows better than Adam, when he, as Minister of Justice over the past 2 years, tried to pass reforms to fix what the populists destroyed, and ultimately could not succeed simply because there was no functioning constitutional review mechanism to control the veto of the president, and the president would veto any law which would try to reverse the destruction caused over 8 years of the Law and Justice regime. So education was the second field, but perhaps the most important, litigation. Litigation took many shapes. I think the most significant and most visible was protecting members of NGOs, activists, people who protested in the streets against unconstitutional laws. They all needed lawyers. And I'm very proud to say that members of my bar showed up at the police station when women were being detained who protested in support of their reproductive rights, which were being taken away. Members of my bar showed up in droves to act pro bono. Many members of my bar took on cases defending the rights of NGO activists who played an important role in defending the rule of law. But perhaps most notably and exceptionally, when you look around the world, I don't think there's been any situation like this. Many of us ended up defending lawyers and those very few pro-constitutional prosecutors, because it wasn't just, defending judges and prosecutors. It wasn't just the judges who were very courageous, but there were a select few prosecutors who were much more at risk because of the hierarchy within the prosecution office of being repressed and facing disciplinary consequences for merely upholding the Constitution. And many of us ended up defending these judges. Now, it's not because we're exceptional lawyers. It's not because they came to us as individuals. There were more judges who needed defending than there were lawyers who could do so. All of the decent criminal lawyers I know, tens, if not hundreds across Poland, ended up defending judges at one point or another. At one point, we had 19 judges, some of them with over 60 charges each, in my office alone. 19 judges. If before 2016 you had asked me, do I foresee ever defending a judge in a criminal or a disciplinary case, I would say, if that would be the crowning event of my career as an advocate, to have the privilege of defending a judge. It's an exceptional situation, you will agree, and in a healthy democracy, it's not going to happen very often. But because of the sheer number of these repressive proceedings, the slap litigation against judges who upheld the Constitution, very often merely for applying EU law, let that sink in, merely for applying EU law, they face severe disciplinary charges. We had the opportunity to defend judges. So that was one part of the important litigation we did. But there's another important part of litigation that we did, which I think was very successful, strategic litigation, which we all, of course, learned from Adam over the years. He was the pioneer of strategic litigation in Poland when he was still with the Helsinki Foundation for Human Rights. He taught us how to use strategic litigation instruments. And we did this now with the judges. We shaped cases, not necessarily to win them at a local level, but to get them to the Court of Justice of the EU with a rogatory, or to get them to the European Court of Human Rights, both of which, to some extent, now replace the constitutional review mechanism, which had been delegitimized and paralyzed. This was the Constitutional Court, which we spoke about earlier. So these are three fields in which I'm very proud to say the members of my bar were very active. I realize I've gone on and on. It's very difficult to talk about these experiences, which were very emotional for us and which marked certainly a decade of our lives, without going on and on. I think it's important to say that, as Adam mentioned, this can't be reversed easily. When we now go to court, I no longer think primarily, what are my arguments? What's the case about? The first question I ask, who's judging the case? Are they legitimate? Were they appointed correctly? Were they a disciplinary judge under Zbigniew Ziobro? Were they delegated by the minister before 2023 to a higher level court? Were they a beneficiary of the former system? All these issues now matter. And I have to take this into account because I know that these judges will apply a different legal regime than the old pro-constitutional judges. There are, in fact, two legal regimes which we have to deal with and navigate that. Before 2018, I never filed a motion for recusal of a judge. It would never happen. It was absolutely a last resort and awkward at best, shameful potentially. Since 2018, I've lost count. I've lost count, and it's not something I'm happy with. It's not something I'm proud of. It is a necessity because we need to exhaust domestic remedies in order to get our client to the European Court of Human Rights. We no longer have a constitutional review mechanism, as mentioned earlier. So all of this has affected the belief of our clients in the fairness and legitimacy of the legal system. It's extended the duration of proceedings immensely, which further undermines credibility of the court system. And there is no light at the end of this tunnel as of today. When President Nawrocki was elected as the president of Poland following Duda, we understood that no laws to fix this situation were forthcoming. I don't think we'll be going back to anything resembling the Poland before 2015. What we can hope for now, and this is what gives us strength to continue to persevere in upholding the constitutional, the very values which are the core of our profession and so important to rights and freedoms, is the hope that these values will, in the future, act as a compass in reforming, creating a new liberal democratic constitutional quality in our state. I no longer believe that it's possible to fix the damage done and get back to where we were previously. Perhaps that is not a very optimistic note, but it's I believe it's a fair assessment of where we are right now, and perhaps it is a warning to all the lawyers across the world who would be naive as we were in 2015 and 2016, believing the institutions would defend themselves, believing this can't happen to us. Thank you very much.
Well, thank you to both our speakers for your very well-informed and frank and, may I say, passionate descriptions of what is happening, what needs to be done, what has been done, and what needs to be undone, if I can say that. A lot of food for thought, I think, for everybody here. We will open it up for a discussion in a moment, but as chairman, I get to ask a question. A lot of your focus is on constitutional cases. I wonder whether the work of the courts, the work of lawyers, yes, it does involve those sorts of cases, but there's also a lot of ordinary disputes that don't raise constitutional or public law issues. People being hurt in car accidents, people having building work done and falling out with their construction company. The sort of bread and butter case of the legal system, the judicial system here, I assume goes on in Poland as well. And is there something that you... and here I think one of the things that the House of Lords Committee stresses, and a lot of politicians stress, is the importance for business of a fair and well-respected judiciary. And I wonder whether there is in Poland any pressure or concern from the business community, from other branches of the law who are using the courts and who need that kind of judiciary. Is there any pressure from them, or have you had an opportunity to bring them into the debate and harness whatever pressure they may bring to improve the judiciary? I wonder, Adam, if you could speak to that.
Of course, sure. I think it is extremely important question. Our problem is that at certain point we started to feel that these are not just abstract discussions concerning values, but that the situation in the judiciary has impact on life of regular citizens in their daily cases. Maybe I will just give you one example. For example, I remember one case about a Belgian father who had a daughter. His wife has escaped, abducted their child, and she returned back to Poland. Then his wife died, and the kid stayed with grandparents. And he used all different possible legal avenues in order to get back his child. And it was quite obvious that the authorities at the time started to use this case in a political way, in a quite, to be honest, nationalistic way, and they used different specific measures and remedies in order to, I would say, put this political effect on this case. And basically, he didn't get back this child as long as the new government came in 2024, and we started basically not using that kind of procedures, and judges started to feel that they may behave simply in accordance with relevant EU law and human rights standards. So the natural father got back his child. But coming back to, so it is just one of cases, but we could see that especially the use of some extraordinary appeal measures that appeared in the system has been used in order to achieve a certain political effect. And the second point is that depending who is a judge, as Mikolaj made this point, you could expect different results. And if you had a judge who was like a purely political nominee, so let's say a judge who has been delegated first to the Ministry of Justice, then got a nomination to the higher instance, and you had a case of some, let's say, political nature, you could expect rather a judgment that would be sympathetic to some political interests. When it comes to the business community, of course, business community was concerned over this period of time. I would say, and maybe I think it's a risky business to mention this name, but I remember one lady who visited Poland in 2016, and she was like a keynote speaker presenting this kind of idea, connection between the business and the rule of law in 2016, and it was Lady Sherry Blair. So it was one of the conferences organized by Michał Wawrykiewicz, by the way, at that time. I know that her name is right now a little bit controversial because of representing some, let's say, interests. But business basically was interested in the legal stability, but there was like something more. First of all, please look that one of the, let's say, those measures that have been introduced was not only, let's say, attempt to subordinate courts, but like the total subordination of the prosecution service and total lack of accountability for abuse of power by prosecutors and also using prosecution in order to achieve certain political purposes. And there were some business people who were very fearful of pretrial detention, of charges, of prolonged investigations, and moreover, the previous Minister of Justice was Zbigniew Ziobro was pretending to be that kind of a sheriff that he's controlling like the whole state apparatus and the prosecution. And of course, from the point of view of the business community, it was a situation of danger. But on top of that, please look that we had like ongoing problems that were lasting even before 2015, like for example, abuse of the pretrial detention. So the business community was involved, not only saying that they are against those, let's say, illiberal practices, but also that they would like to see the justice system that is reformed, especially when it comes to the criminal justice. And here we could feel some level of cooperation between NGOs, Bar Association, and the business community over that time.
And when you were talking about, very movingly, about the numbers of barristers and advocates and lawyers who were protesting, was that mostly people who do political criminal cases, or was it across the whole range of work?
It was, I hate to blow my own community's horn here, but it was, of course, predominantly criminal lawyers. Criminal lawyers tend to be the punk rockers of the legal community, so they were at the forefront. But what surprised us in a positive fashion was that these were lawyers who would normally be doing commercial work, tax law, labor law. They were lawyers from individual firms and, well, incredibly large firms like Clifford Chance. You had lawyers getting very involved, hands-on, and providing the kind of support for the rule of law that individual law firms could not. So it was a very broad spectrum, and to this day, I really cannot say why this was so successful in Poland and was not successful in many other places where the rule of law is threatened. If I may invade upon the previous question, Lady Rose asked about business. I've had many concerned clients, business clients, companies who litigate in civil cases, and they're also very concerned about whether they're going to get a fair judge or not. And if you're in a criminal case and you're on the side of the defendant, the accused, and you get rid of the wrong judge, the neo-judge, the illegitimate judge, that removes the argument, or that removes the issue that the client may have regarding the lack of objectivity in its external aspect. The judge is now, for better or for worse, a credible judge because they've been rightly appointed. But in a civil case, if you have the wrongly appointed judge, somebody's going to always be unhappy. If the wrongly appointed judge acquits one of my clients in a day-to-day criminal case, which has no political impact at all, then you might say, well, see, the system worked this time. That won't be the case in a civil case. If the wrongly appointed judge in a civil case between two independent parties makes judgment, there is a party that's going to be ultimately unhappy. And I think this problem was addressed by the Court of Justice of the European Union, initially in Selmer, and then later on by the resolution of the three chambers of our Supreme Court. So in yesterday's judgment, effectively requiring a two-tier test. I'm not a fan of the two-tier test. It means that, well, these illegitimate judges, they're certainly illegitimate at the Supreme Court level, regardless of the nature of the case. But at any lower level, appeal court, circuit court, district court, it all depends. They're generally illegitimately appointed, but in order for them to be recused, you need to prove one more factor, an individual factor, the impact on the case. And I understand that that's a balancing act which the Court of Justice of the European Union and our own Supreme Court tried to perform in order to preserve the day-to-day functioning of the courts, so they wouldn't be paralyzed for years on end. I'm not a big fan of that solution, but it was perhaps a necessary one. I have the very difficult role, believing very strongly in that the rule of law was violated, that these judges are legitimately appointed. I will find myself in situations where we have a criminal case with a client, and I will say, look, this judge was wrongly appointed, but we don't pass the two-tier test. We won't make it to the ECHR, and I don't think you're going to necessarily get a better judgment if we have a legitimate judge. So I find myself where I'm bound by ethics to advise the client, let's stick with this illegitimate judge. A very difficult balancing act, and one which I perform sometimes with great distaste.
Thank you very much. Questions from the audience who would like to...
Or perhaps scathing critique.
Do you like? Yes, thank you both there. I think there's a mic, the roving mic, the inevitable roving mic, yes.
Thank you very much for your invigorating and worrying addresses to us. Where did these lawyers come from, or at least where the ones who filled these positions illegitimately and obviously share a certain nationalistic ideology? Is there a law school that has trained them? As in Germany, it was the Kiel Law Faculty which trained many of the Nazi lawyers. Is there an organisation in Poland equivalent to the, I don't know, the Heritage Foundation, which has basically chosen most of the American Supreme Court? Where, are there bodies which have been very effective in achieving this dreadful state of affairs?
Yes, so you did mention that there are different sort of rookies, you called them, straight out of judge school, some who are moved it from the professions or from academic life, and some who are promoted for more junior judicial roles. So you seem to have a mélange of different judicial appointment system, but where are those judges coming from, and how are they being selected? Adam.
Thank you very much for this question, because to a great extent it allows me to give some view on the other part of the, let's say, legal story, because Mikolaj perfectly presented the story of the heroism of Polish judges, of Polish attorneys representing them, also of Polish prosecutors. Please look that we had quite a significant group of more or less 200 prosecutors that decided to create their own association, which was named Law Above All, and they were more or less protesting, doing also some civic education, promoting like the vision of the independent and integral prosecution service, a little bit, and risking their whole professional life. Because with prosecutors, I claim even that if Law and Justice will be still in power, all those prosecutors working for cooperating with this association, Law Above All, they would be already fired from the prosecution. Okay, but yes, that is true that all those reforms would not succeed if not support of, let's say, loyal lawyers. And I think that was quite interesting what you have said, because I think that the last thing I would say about them, that they were ideologists, that their motivation would be based on some kind of ideology. In my opinion, with respect to most of the cases, it was just pure opportunism and career. So for example, let's imagine you are a district court judge working on labor cases. You are already there for, I don't know, 10, 15 years, and you would like to be promoted to the higher instance. You know that there is this problem with the National Council of Judiciary, that some judges protest, that it creates some kind of a controversy, but at a certain point you are closing your eyes and saying, okay, yes, but there is no any other National Council of Judiciary, I go there, okay? So those people who decided to be promoted, they were mostly like this, okay? They were kind of accepting the system. When it comes to those rookie judges, simply they were graduates of the law school. They started training in the National School for Judiciary. We have this kind of a French-German system that after finishing the law school and the School for Judiciary, you could become apprentice judge and then a judge. So simply also they were in a position of not having any other possibility. They have chosen that kind of a career track. So they were promoted. And I wouldn't say that they gained some kind of ideology through that time. Rather simply, they were just interested in this professional development track. And interestingly, quite often, people say that they are of quite good quality judges. And interestingly, after those 2023 solutions, legislative proposals how to resolve the problem, we named them a so-called green group. So basically, we claim that whatever legislation, we should simply approve their nomination and not challenge them. But the major problem is the Supreme Court, and the major problem are those, let's say, promotions of some people who are connected with the Minister of Justice. So, of course, some of them were believers in the new system. Some of them, let's say, were right-wing oriented. Some of them were affiliated with the organization which is called Ordo Iuris, which is like a Christian kind of MAGA fundamentalist-oriented organization, and with a very strong influence on the justice system during that time. So you could have a kind of a mixture, but at the end of the day, they captured the Constitutional Court and the Supreme Court. So I would say at those top levels, you could see people who had like this very strong political affiliation, and it is important part, because when we started this process of the rule of law recovery in 2023, they didn't feel kind of ashamed, okay? So it was not like, okay, yes, we participated in some like a wrongful system. Quite otherwise, they were doing, and they are doing until today, everything what is possible in order to defend their position, in order to kind of confirm that their choice that has been made, this professional choice, was correct, and everybody who is kind of promoting jurisprudence of the Court of Human Rights, Court of Justice, and this kind of a thinking about judicial independence is simply wrong. And moreover, they are using also their judicial authority in order to protest against this. So that's why, especially in the Supreme Court, we have like a very, very strong division, very strong polarization these days. But maybe I wouldn't say that there was like one grand ideology behind it. I would rather say it was kind of a mixture of some political interests, opportunism, and also, please, maybe that would be like the last sentence, that Law and Justice quite smartly invested in people who did not advance their career in a proper way before. So it was quite easy to attract those ones who wanted to become quickly judges of the Supreme Court or judges of the appeal courts. You know, so you may always find people who would not be that much concerned with some ethical or constitutional constraints. They would accept that kind of a promotion.
Mikolaj.
I think that's an excellent question, because Mirosław Wyrzykowski, who was a mentor to both, particularly Adam and myself, a constitutional court judge, esteemed law professor, would consistently remind us over these years that lawyers are the midwives of authoritarianism. These changes don't take place without the participation of lawyers. These corrupt authoritarian systems need rules, they need laws. Somebody has to design this pro-executive system at the expense of the judiciary. This doesn't just happen. They needed their lawyers, and those lawyers would have to be tempted to come over to their side. And in practice, my observations are perhaps far more... Adam was very kind and very, very gracious in how he views this minority of the legal community, because they were a minority, which I think has to be stressed. I think, judging by the people who came from our bar association, ended up being judges under the law and justice regime, who ended up being high-level prosecutors under the law and justice regime, having no experience as prosecutors thus far. These were people who faced multiple disciplinary actions before the bar, who, over a period of years, were unsuccessful in building a reputation, a portfolio of clients, quite simply were unhappy with how their career was going, for reasons which perhaps were somewhat attributable to their own life decisions and motivation and willingness to work and devote time and energy. The law and justice managed to manipulate the sense of frustration, insecurities, and desire for quick advances in the legal community. I think every community, not only legal community, has a certain group of people who may be very intelligent, but have a weak ethical backbone, regretfully. And law and justice pushed all the right buttons. And they hit all the right notes to speak to these people. And these people who were frustrated, they weren't advancing within the current prosecutorial organization or in the courts. They were low-level judges for 15, 20 years, and there was nothing on the horizon to suggest they were going to deserve an advance because they were lousy judges. And they got what law and justice did to them, but also to other spheres of Polish society, artists, economists. They said, you're not bad. It's everyone around you. You deserve more. And they manipulated these insecurities in the sense of frustration in every community, including the legal community, saying, now you're going to be our lawyers. And these people advanced 5 stages overnight. They suddenly became Supreme Court justices. And I'm going to, nomina sunt odiosa, but these people deserve to be named and shamed. I think naming and shaming is a very powerful tool in civil society. Piotr Schap, who was the most radical and draconian of disciplinary judges acting under Zbigniew Ziobro, formerly a relatively respected criminal court judge. None of us could believe this man took the opportunity to advance opportunistically under this regime. But when I later spoke with his friends, they said, look, he has been boiling under the sense of frustration that he's not appreciated enough for years. He always felt underappreciated. And law and justice played on that sense of frustration and underappreciation. Many other people, Przemysław Radzik, Michał Lasota, I believe they deserve to be named and shamed. Mm-hmm. They were completely marginal judges who had not advanced in their careers for decades. They advanced to position number 1 overnight. So these people were given an opportunity which they would not have because law and justice managed to tell them, look, it's not your fault. You're wonderful. It's everyone else that's wrong. So they spoke to that minority in that way. And I disagree with Adam in his very gracious approach to rookie judges. Answer a question. If you were in the position of a person who had just completed law school in Poland and now had the opportunity to go to the 3-year judges school, we have a very Prussian model of creating technocratic judges through a school rather than having them accede to the judicial profession as the crowning of the legal career, which I always disagreed with, but that's how it looks. Now, would you continue, even if you were in first year in that judicial school, would you continue, or would you say, look, this is my first test as a future judge. If I agree to go down this road, that means my back is broken ethically. I start my career as a judge with a fundamental ethical and legal compromise. Do we want judges whose entire career starts with a fundamental compromise on a very basic constitutional issue? I would say no. So no, I have very little understanding for those people. What I had expected from the school of judges is a massive exodus. That didn't happen. Not good news for the future of the judiciary in Poland, let me tell you. You have an entire generation of young judges who started their career with having their backs broken.
With a moral compromise.
So I disagree. It's not their fault. They found themselves in that time and place. But they were faced with history said, I'm now testing your ethics. And history faced them with this decision at the very beginning of their career. Most of them failed.
Okay, so I have to respond. I think that when I was the law student, I was lucky enough to have a great mentor who was named Professor Mirosław Wyrzykowski, a great constitutional scholar, former judge of the Constitutional Court. But being academic teacher, I know Polish law schools, and I know that they do not educate properly on, let's say, on this level of constitutional values and ethics. And I think there is no discussion about that kind of issues. I think to a great extent, law schools are training young students of law, young professionals that are going to make a career, but this word career is not equipped with proper attachment to values. So that is why, so my feeling is that they simply do not have it in mind that they might have some bigger questions concerning this, because there is no law teacher that would tell them this to have it in mind. So they don't have. They are not, from, let's say, Warsaw University, Jagiellonian University. They are from plenty, other universities where there is no discussion whatsoever about those issues. I wanted to just add two more things. I think it was quite important what Mikolaj said about naming and shaming individual judges. There is a very important role is played in this context by the jurisprudence of the European Court of Human Rights. And I would like just to give you indication of just one judgment, which was in fact litigated by Mikolaj and his colleague Małgorzata Mączka, Biliński against Poland. Quite easy to remember, Biliński against Poland. It was just a case about compulsory moving of a judge from a criminal division to the family division. So just imagine judge former prosecutor who was doing, criminal cases, then he became a criminal judge, and then he was just moved from one day to the family court.
After 20 years in a criminal division.
And it is interesting because when you read the case, you see, which people made those decisions, and how they did this decision, how they manipulated the system in order to achieve this effect, and basically those names remain. Okay, we have those names in this jurisprudence of the European Court of Human Rights. The second point about those personal choices, I think one of the motivations for those choices of people getting into the system is the precarious nature of the Polish legal professions and quite significant level of remuneration which is right now given to judges and prosecutors, especially taking into account that at the end of your service you are having a retirement in the amount of 75% of your last remuneration, okay? That is really like a treat, okay? So I can imagine that for a number of people getting into the constitutional court or to the court is like this, okay, I'm getting into the system and my retirement is fully secured. So I think that was one of the motivations for a number of people to join the judiciary.
Okay, thank you very much. Fascinating.
Hello. Oh, sorry.
Another question. Yes, thank you.
I just wanted to add something, and forgive me the encroachment, but I speak from personal experience, so perhaps there is a bit of nuance that I can add to this gentleman's questions here. A friend of mine, I am a Polish lawyer and I'm an English lawyer as well. I studied in University of Łódź in Poland, which I have always considered a very good, one of the top law faculties of the land. And a friend from my group who was one of the best of us and a really red-hot lawyer acceded to a Supreme Court position. And the layer of nuance that I wanted to add is that it doesn't have to be a case of a frustrated individual whose career doesn't progress at a pace or at a rate that they expect. We are talking about a highly skilled lawyer in whom I would have every confidence that he would deliver the outcome for the client as an advocate or a sound judgment as a judge. He just took a shortcut in a career. So my
too much personal.
Yes, no,
but it's
the
power of vanity is.
But vanity and frustration may exist, perhaps even more so among highly intelligent or highly skilled. We saw that on many occasions. We saw high-level law professors, certainly intellectually my superiors by far, but they didn't have the backbone. They had they stood to gain from this choice.
But I think also as a judge, you go into I would think that some of them go into the job thinking, yes, this is a terrible system, but I'm a good person and I will be able to do a little bit of good when I can without jeopardizing my 75% pension, without causing too many problems, but I will be the judge before whom people will come and say, oh, well, thank goodness we've got him, or thank goodness we've got her, because although they were appointed by the system, I know that to the extent that they can, they will be better than they need. And I can see that kind of moral compromise is what goes on all the time. Stephen, you wanted to. Thank you for...
Firstly, thank you very much. To take the opportunity to say these contributions have been fantastically interesting. I was particularly interested in the description of how lawyers were deployed, and judges, to defend the rule of law. Amongst ordinary people who are not lawyers or closely acquainted with the law, an awful lot of people think that the rule of law is a lawyer's game. It's something that lawyers invent, and that it's nothing really to do with them. And there's also the notion that whatever is expressed through electoral majority necessarily carries legitimacy. And it doesn't seem to matter in many people's minds whether the electoral majority is driven by ignorance or unrealistic expectation or irrational beliefs. So when you went into the community to defend the rule of law, how did you navigate the notion that this is just lawyers arguing about something technical? How did you deal with the sources of legitimacy which don't come from the ballot box?
You go first.
That goes to the very hardest task we face and continue to face. How do you convey to... well, children in schools actually understand. The problem is when they get a little older. Once they've left high school, once secondary school, they're university students, and they seem to disconnect from the Constitution, because when we speak to preschoolers, elementary school, and you explain these relatively simple concepts, they nod, they understand, and the conversation suggests that they actually have internalized what we talk about. But then with people who are a little older, they don't see how rule of law applies to them directly. So what we tried to do was set up workshops and court simulations, create case studies and examples which could be relatively easily conveyed to illustrate why having an objective judge, a properly appointed judge, is important to you. There was a very famous case where Prime Minister Beata Szydło's car, a cavalcade of government cars, rammed into a tiny Seicento car driven by some local farmer. And of course, this farmer was immediately accused of having caused the accident because it couldn't have possibly been the cavalcade driving 180 down a country road in the middle of the night. And the lawyer who showed up representing the local farmer was criticized by the Minister of Justice and prosecutor at that time at a press conference for daring to suggest that it could have possibly been the driver of the government cavalcade. And that was a very good example. That showed how the system works against the little man if they're facing anybody with any political connections. We try to use examples. What if you've got a civil case regarding the fence between your property and your neighbor's property? It happens. And especially in Poland, we have a lot of cases about fences. Imagine if your neighbor is related to or married into the family of a local law and justice council person. How do you think you're going to fare before a judge that's been appointed through this new National Judicial Council? Perhaps the judge will be fair, but do you feel that this is a credible situation is that external aspect of judicial impartiality present in the court. And I think the Seicento case was very helpful because it was a real event and people were very upset by it. And it showed how power, political power can enter the courtroom for anyone.
Do you want to come back? Because I want to take one last question and then we must...
Just shortly. I think it is important to note that as a part of accountability for past abuses, we do a lot of different things. It is not only the action of the prosecution service or investigative committees, but there is also like a special committee created under the umbrella of the Prime Minister that is checking different abuses towards civil society, human rights defenders, and also journalists over those 8 years of illiberal regime. They have just produced 2 days ago a report counting 600 pages, remarkable report, for example, presenting the use of the SLAP litigation techniques, so strategy lawsuits against public participation, or the abuse of some different inspections or some prosecutorial actions in order to silence or to target activists. So sometimes, you know, it was not only this, let's say, Seicento driver case, but you could feel on a daily basis that people are facing different reprisals for their activities. That you have some people, especially connected with some courageous NGOs, that are simply on a daily basis feeling, you know, what does it mean that you are the target of the public power or the target of the public television that was really very intrusive into people's privacy and in presenting people in a negative way. So I think using that kind of examples, it was much easier to convince, listen, that is what we are fighting against. You should have a fair trial. You should have a right to a court. You should have a right to independent operation of different state institutions. But I think in your question, there was a very important element regarding this, let's say, supremacy of the parliament, result of the electoral vote. I think because we were facing this moment of transformation after '89, we really believed and we structured our institutions in that kind of a more like a checks and balances system. So that it is not only division of powers and the judicial independence, but that also we have a number of different independent state institutions that are controlling each other, like the Supreme Audit Chamber, Ombudsman, and the Constitutional Court. And somehow it became a little bit part of the imagination that if you are having the, even if you are winning the elections, it doesn't mean that you may do just everything. So somehow there was this kind of a feeling that you may, you have a right to restrict the operation of the parliamentary majority in that kind of a situation. Thank you.
Thank you. Final question.
Yeah, thank you so much for such an interesting conversation. I apologize how late I'm asking this question, and I just didn't want to miss the opportunity to ask this excellent group this question. But you mentioned the United States, and this might be a little bit of a personal question, and I apologize for the group. Obviously from my accent, you could tell where I'm from. But you know, in the United States, I think from personal practice, but also pretty obvious to everyone, the erosion of the rule of law, you know, in that country has become pretty apparent. You know, principally with the executive who's instructing a Department of Justice more so than we've ever seen, you know, a single president do ever in United States history. You know, you see it in the suspension of constitutional rights, such as due process for minority groups, et cetera. And you see it manifesting in other ways, you know, going after law firms and their clearances and whatnot. You know, I think, you know, it stems from a place of fundamental distrust in the system to begin with in electing a person, despite, you know, knowing that these things might arise anyway, and that person being there. But my question for you all, you know, obviously being on the front lines of a rule of law crisis in a democratic country, and, you know, being the soldiers on that front line and fighting it and seeing everything that's been going on in your country, what are the parallels that you see with what you've been through in Poland and with the United States going through right now? And also, do you think, you know, I think you mentioned earlier, it could be irreparable at some point. Do you think the institutions have been so damaged so far that it's irreparable, or do you think, despite us not having a ECJ or ECHR, that there are ways for us to avoid that damage?
Thank you. Who wants to go first on that one? Adam, I think that you may feel you have enough problems to solve without starting to solve America's.
Sure, I have a lot of contacts with let's say, liberal groups, civil society, bar association from US, and I must tell you that the imagination of how you may restrict integrity and independence of different professions is just tremendous. For example, Mikolaj mentioned this case of law firms. I wouldn't even, think that any government may ask law firms to provide, some hundreds, thousands of pro bono hours in order to support the administration. And if you are not producing this result, then you are subject of different sanctions. That was out of my imagination. But I was trying to follow more closely the situation of prosecutors, so Department of Justice attorneys, and I think it is something which is I think that we are missing sometimes the point how painful damage could be, because in this case, you have people who are believing in a system, who are working in the system, and on one day they are just kicked out from the Department of Justice, and I think that this damage which is caused is how to rebuild it when you are breaking a certain trust between somebody who is getting into civil service, and moreover, he or she does not have a guarantee of coming back to a typical attorney profession. I have even written a post for such a website which is called Democracy Project, which is managed by the NYU Law School, in which I have presented such a vision, hope maybe, that something that could be shared from Poland is the vision of solidarity. That what is important is to show solidarity to people that are treated this way. And that this solidarity does not mean that you must create some big structures, but sometimes some just individual support to people who are treated this way is something important for values to survive. So maybe I would like to just recommend reading my piece on Democracy Project on solidarity. Thank you.
I would answer your very astute question by referring to Timothy Snyder and 20 lessons from the 20th century on tyranny. I remember opening the little booklet and saying, this is us. Yeah. This is us. Now it's you. All the mechanisms of tyranny we've seen in the 20th century are mutatis mutandis. They were applied in Poland and are now being applied in the United States. Of course, the smear campaign against political opposition and civil society that there is opposed to the executive, the repression of private media and independent media, the paralysis or delegitimization of those parts of the judiciary which are not favorable to the current political power. We've seen that. I'll be very blunt, on the one hand, I was delighted when the president of the ABA came to every one of our Warsaw Bar Assemblies for 4 years. The president of the American Bar Association would change every year, but each new president would come, and that was an immense gesture of support. It meant the world because we weren't alone. We knew that, America sees us, and America has a very important role to play from the Polish perspective for historical reasons. And then to see that the American legal community was not nearly as adamant as we had expected in resisting political pressure, it was a surprise. And once again, I can't tell you why the Polish legal community was relatively, if not unanimous, but was strong, where in other states who we've always viewed as much more attached to democratic tradition, this didn't happen. You ask what lessons can be learned, or perhaps what do we see, what parallels? I think symbolic gestures matter. When I started observing what happened, resolutions of bar associations, there are leaders and smaller, greater leaders on different levels in the legal community and in civil society. People are going to look to them to speak first, to point out wrongdoings and saying this is wrong, and other people will follow. Adam was critical in that role. Once again, I'm so sorry, Adam, I know you don't like this. If Adam hadn't been there, if he hadn't been the first to say, look, this is wrong, and made a very clear argument, many NGOs wouldn't have followed, other lawyers wouldn't have followed. Local bar leaders had to speak out. I think that's something we should be seeing in the United States, and we're not seeing on many levels. Individual gestures, symbolic gestures, like the presence of the American Bar Association president at our bar assemblies matter, because people follow these gestures.
Thank you. I think that is an excellent note on which to bring this evening to an end. And I would like to, and I hope you will join me in thanking our speakers, not only for their honesty and the comprehensive and fascinating nature of what they have told us here, but more broadly, I think, to salute them and their courage in what they've been doing. I think, as lawyers, we always think as we start out or as we reach a new stage in our careers, how would I behave? And here I think we have two beacons of how I hope I would behave, and I'm sure you join me in hoping that you would behave if you were put to the test as they have been and are being put to the test. So please join me in thanking them.